All right, welcome back. Thank you for your patience as we went through the fire alarm. I think that for the burning questions that you have for the past panel, you will. They are still around if you'd like to ask additional questions of those folks. So please do find them after this panel is over. I'm delighted to move us on to our final panel of the day, and our final panel of the day is on MDLs and related state consolidated cases. And another member of the Judicial Education Advisory Board, Judge Anna Manasco, is joining us to lead us through this discussion. Judge Manasco is a judge on the U.S. District Court for the Northern District of Alabama. She earned her BA summa cum laude from Emory University, her Master of Science and her Doctor of Philosophy from St. Edmund Hall in Oxford, and her Juris Doctor from Yale Law School. She was a clerk to William Pryor in the U.S. Court of Appeals for the 11th Circuit before going into private practice and then being appointed to the bench in 2020, or being confirmed to the bench in 2020. And so we are delighted to have her here to help us make sense of MDLs and to use the panel as a way to facilitate that discussion. So, Judge Manasco.
Thank you very much. Let's see, can folks hear me? Okay, great. Well, I'm really thrilled to be here. This is a very exciting panel to have an opportunity to participate in. We have four practitioners here, and I'll let them each introduce themselves, but I'll give you the high-level overview, which is that between the four of them, they have decades and decades of practice in many different kinds of MDLs from multiple different viewpoints. We have some from a public viewpoint and some from private practice viewpoints. And I believe in Mr. Trask, we also literally have the author of the book here with us on class actions and a number of other books. So I'm very excited as a judge to hear from them and their perspectives. And I'm going to invite each of them to make about 10 minutes worth of opening remarks. And then depending on how well we steward that time, we'll have opportunity for some responsive remarks and questions from the audience. So I'll turn to Mr. Budner first.
Hello, everybody. Good morning. My name is Kevin Budner. I am at the law firm of Lieff, Cabraser, Heimann, and Bernstein, and we do all manner of plaintiffs' work, but mostly class actions and mass actions. I myself have had my fingers in all sorts of different pies, but I have, as relevant to the last panel, been heavily involved in the opioids litigation and currently in the climate change litigation. And before we jump to the topic of this panel, which will be very engaging, let me just take a quick moment to note on the last topic that the characterizations of nuisance law that you heard are not without some dispute. Just say that there are different views of what nuisance is accomplishing and how the current slate of cases maps onto nuisance law. I would just offer that there are different perspectives on nuisance being a tax on lawful commerce, and that there's oftentimes a focus on unlawful and deceptive behavior. So I'll just leave it at that and move on. So today we are talking about MDLs and their effects on dockets. And my perspective will be largely that their effect is positive and that they are doing largely what they're intended to do, which is driving efficiency and fairness. And I will address what I think, from my perspective, is a little bit of a boogeyman in the statistics-based arguments about the growing size of MDLs and sort of as a result, their negative effect on caseloads generally across the courts, and talk a little bit about why I think they're working, notwithstanding the fact that they constitute a significant number of cases in the dockets across the country. And I expect we'll talk a little bit about some of the ways to make them even more perfect through new and emerging rules and best practices. So let me start first with the boogeyman. I have read lots of articles discussing how MDLs make up some 70, 75, 80% of cases that are filed in federal court. So that is to say, of all of the cases that are filed in federal court right now, some 75% of them are housed within MDLs, okay? And that seems scary. That seems like a lot. That seems like a big shift. And I think that if you peel back those numbers a little bit, it's not quite what it seems. I do encourage people, if you want to geek out on MDLs, to go to the JPML's website and play with their statistics. There are lots of stats, enough to support really any argument, as you may be about to find out. But what I think they show are a few things. First of all, I think there are 402,000 cases right now, individual filed actions that reside within MDLs as of 2023. There is one case, the 3M earplug case, that accounts for 56% of those actions. All right, so you take out this one, albeit very large and complicated MDL, but I would posit mostly an anomalous MDL. You take it out of that pie and it starts to change the numbers a lot, right? All of a sudden it starts looking a lot more balanced than it did otherwise. Two, another statistic that the JPML offers is the fact that petitions for MDL formation are actually on the decline. From 2014 to 2023, they've been on a steady decline, going from, I think, 89 petitions were filed in 2014 down to 29 in 2023, so about a third. The number of MDLs that have been formed has also been on the decline, not quite as steady, but going from 40 some odd to the 20s. So there too, what we're actually seeing is a decline in MDL formation. So not, I think, the big monster that's jumping out and transforming, radicalizing the courts and the dockets. All right, point three, statistic-based point number 3. 56% of all active MDLs contain class actions. Right? They have within them class actions. So you may have, in those cases, lots and lots and lots and lots of filed individual cases, but they're not being litigated as thousands of individual cases. They're being litigated usually by one master consolidated pleading in an orderly fashion. And when decisions are made, they affect almost all of the cases, and they're being resolved relatively efficiently. One example would be the Volkswagen Clean Diesel MDL, which had at its high water mark some 2,000 filed cases, according to the JPML statistics. That case was resolved the vast majority of the case was resolved through 2 or 3 class action settlements in a year and a half's time. Right? So those 2,000 cases and the hundreds of thousands of claimants that those cases represented were resolved pretty efficiently and pretty quickly. And so it's an indication that where the MDLs have class actions within them, they're maybe not quite as voluminous as they seem. Another example would be that lots of cases that have high numbers of filed cases but are mostly resolved. And I would point to the opioids MDL as an example. And yes, the opioids MDL continues. And yes, it's been going on for a very long time. And according to the JPML, there are 3,000 plus filed cases still within that MDL. But the vast majority of those government plaintiffs have resolved their claims against the manufacturers, have resolved their claims against the distributors, have resolved their claims against the pharmacies. So all of this is sort of in furtherance of my overarching point that the MDLs are not crowding the docket. They're not creating this unmanageable force that one might think they are at first blush at the statistics. Okay. My second point is that even if MDLs are a big part of federal practice and coordinated proceedings in various state practices. That is not a bad thing. That's overall mostly a good thing. MDLs were created, coordinated proceedings were created to drive efficiency. I'm guessing that all of my panelists are going to say there are some significant efficiencies to be gained through coordinated proceedings. So I don't think we should lose sight of that sort of fundamental baseline, which is that coordination was created for a reason. And I think back to a case that I had, 12 years ago. We had a products case involving a Medtronic spinal fuse product. We'll go into the details. But we're not in an MDL, and we only had a few dozen cases, and I think that the defendants had a few other law firms that each had a few dozen cases, so they had maybe 100 cases altogether. And there was a decision, maybe a little bit of a game of chicken. Nobody petitioned for an MDL formation. And so as a result, we were litigating dozens of cases in jurisdictions across the country, oftentimes briefing the very same issues before one court, turning around and briefing it again in another court, from Texas to Colorado to California, asking, in this case, all of the courts to decide the same preemption issues, the same set of legal issues. I remember seeing the defense counsel in those cases and thinking, like, I'm barely sleeping at all. I don't know how you're even alive doing 3 times as many of these cases in jurisdictions across the country. And that burden on the litigants and on the courts, they could have been pretty easily avoided had we moved towards coordination. If you apply that same principle to the 3M earplug litigation that I referenced earlier, what happens if you take hundreds of thousands of claimants, and even accepting the premise, as I'm sure we'll get into later, about whether there are some non-meritorious claims, right? Even accepting that some percentage of them maybe wouldn't exist, there's still hundreds of thousands of left. What do you do if there's no coordination for those hundreds of thousands of claims? All right, so mindful of my time, I'm going to make one last point in my opening remarks. And I'm going to cheat a little bit because one of my co-panelists opened one of our email conversations or invited us to talk about the field of dreams problem, I think is how it was phrased. Right? The idea that, and I'm really sorry if I'm stealing somebody's thunder here, the field of dreams problem, all right? I don't know, and I think the idea here is if you build it, they will come, right? If you create a structure for mass litigation, plaintiffs, litigants will flood into it, and you'll have a problem. You'll have litigation that you would not otherwise have had. Okay. I don't know who's seen Field of Dreams, but the 1919 White Sox or whoever it was who went out to that field were not a problem. All right? That was a welcomed addition to that cornfield, was having people who otherwise would not have been there and who got to play baseball one last time. Right? So I don't know that I agree with the premise that creating mass litigation infrastructure is inviting more claims. But if it is, isn't that a good thing, right? Isn't it a justice enabler if we are inviting more claimants to come and vindicate their rights in court? And if it turns out that some small percentage of them, and I'm sure you'll hear that it's a really big problem, and we'll get into that later on, that some small percentage of them lack merit, there are methods. We have methods to administer cases in a way that we can identify cases that shouldn't proceed, and it can be done early. It can be, as we'll discuss with Rule 16, there are going to be mechanisms that judges will be invited to use to start to identify those cases early on. They can be identified in a settlement structure that doesn't provide compensation to claimants who don't have proof of injury. There are lots of ways to deal with the marginal cases of potentially non-meritorious claims, but overall, the aggregate litigation and the MDL model is providing more access to justice, which is a good thing, and I would posit is not overwhelming the courts at a grand scale.
Excellent, thank you. Excellent. All right, Mr. Feldon.
Hi, my name is Gary Feldon. I'm a partner at Hollingsworth, L.L.P. For those of you who aren't familiar, we're a litigation boutique that does a lot of consolidated litigation. Since I've been there, I've been working almost exclusively for defense-side pharmaceutical MDLs. But prior to joining the firm, I was at the Department of Justice, where I was involved with both the National Prescription Opioid MDL and the 3M litigation as a third party. And before that, I did some class action work. So my perspective is obviously a little different as a defense practitioner. I think we all recognize that MDLs are perhaps a necessary evil. We are sacrificing justice and fairness, individual consideration of claims for efficiency. And that's a necessary sacrifice. As Kevin pointed out, there are too many cases to see every individual case addressed by an individual judge in an individual courtroom. But that leaves us with a problem because, as Kevin mentioned, there are a lot of statistics out there about the prevalence of MDLs in the court system. In fiscal year 2023, MDLs, depending on how you count them, represented somewhere between 60 and 70% of all federal civil cases pending in this country, in the federal docket. Now, that's the highest they have ever been since they were created in 1968. And while that number has ticked up because of the 3M litigation, and we'll probably see a dip now that it's settled, the same driving factors that led to this high watermark are going to lead to the next one. Because MDLs are structured in such a way that they, again, sacrifice that individual judgment in exchange for the efficiency of mass litigation. So why are MDLs growing as a proportion of an already growing federal civil docket? Well, there are only two main reasons why you're going to see more of one type of case pending. Either one, more of these cases are being filed, or two, they're staying on the docket longer. And I think both of these things are driving this problem. In fact, it's no surprise that MDLs have a problem of attracting meritless claims. It's often referred to as the field of dreams. Now, while the 1919 White Sox might not have been an uninvited guest, I assure you that tens of thousands of plaintiffs who are bringing claims that would never have merited individual filing, that lack any evidentiary support, that have clear individual state-specific legal defects, is not a benefit to our legal system. And it hurts plaintiffs with actual legitimate claims because when there is almost inevitably a global settlement of pending claims, unless there is an effective mechanism for culling meritless claims, they get paid out. And that lowers the individual return for those plaintiffs with meritorious claims because everybody is sharing in the same pool. I was speaking with one of our guests earlier, and I compared it to the mortgage crisis. When we're looking at a bellwether case and we have individual markup, we can actually value that case. We have an understanding of whether it's likely to succeed, likely to fail, what the damages might be. When you're looking at a case that's just warehoused in an MDL, there is virtually no vetting of the quality of that case. And as a result, you have an incentive to file. And the filing of claims that would not merit individual litigation is a harm to our legal system. As I said, it harms legitimate plaintiffs, and it's a harm to defendants who are trying to get a fair settlement or a fair resolution of their claims. Also, as I said, we have a problem with MDLs staying on the docket longer than they should. Now, as I said, these are perennial problems and they're well known. So it'd be pretty arrogant for me to stand up in front of this panel and this room of people and tell you that I had a magic solution that no one else had ever thought of. Fortunately, the U.S. Judiciary Conference has been working on this problem for about 6 years. In 2018, there was a formation of an MDL subcommittee to determine whether or not a federal rule could somehow improve the efficiency and the fairness of MDLs in the system. 6 years later, Congress has received Federal Rule of Civil Procedure 16.1 concerning case management, and absent very unexpected congressional intervention, that will go into effect December 1st, 2025. Now, Rule 16.1 at a very high level doesn't do much. It requires the parties to submit their views on various case management issues, and it requires the court to then issue an initial case management order that addresses those issues. Where the rubber meets the road is the issues they talk about. And rather than creating any new tools, Rule 16.1 really recognizes formally and endorses existing rules of MDL case management that enable us to promote efficiency without sacrificing fairness. However, like any tool belt, if you leave the tools in the belt, it doesn't do a lot. So when I'm asked the question of, will 16.1 do anything? The answer is, what will judges do with 16.1? Will they take up the tools that the federal judiciary have found to be effective in resolving MDLs and apply them with rigor and resolve to actually pare down MDLs to what they should be, an efficient system for evaluating the merits of claims? Now, it's not really surprising that we see a field of dreams problem. The average plaintiff in an MDL, somebody who's not selected for individual discovery as a potential bellwether, this is their experience. They see an ad on television, they contact a lawyer, they fill out some forms that don't really get to the merits of their claims, certainly not the individual merits because it's a boilerplate form that goes to everybody, and then they sit. And meanwhile, their claim is given to a leadership council or some centralized organization for plaintiffs, and they wait. And maybe their case is dismissed as part of a motion to dismiss or summary judgment, and otherwise they wait. And eventually a check shows up in the mail. Now, if that's the system, it's sort of not very difficult to understand why people whose claims would never survive a day in court are willing to file. It costs them nothing, or virtually nothing. Their lawyers don't have to do any of the work to develop their cases and do their due diligence and inquiry under Rule 11. And frankly, they get paid. Now, Rule 16.1 starts to address that problem. It endorses early exchanges of discovery, usually plaintiff fact sheets, but please be creative. And it endorses expedited procedures to resolve claims. These can be things like lone pine orders, where plaintiffs are required to produce some modicum of evidence showing they have the necessary injury, purchase the necessary product, whatever. And that plaintiffs who are unable to produce this modicum of evidence have their claims dismissed through expedited procedures. Now, that's a tool, and it's a tool to address the problem of meritless claims, but unless we pick up that tool and we use it to actually address what are the claims that lack merit, that we identify them, that we require plaintiffs to provide the information necessary to do that evaluation, these claims are sitting unexamined. And again, we're not going to get rid of the incentives to file them. It also stands as a real barrier to settlement. As a defendant, especially public companies where you're answering to shareholders, CEOs, you have to answer to your insurers, their reinsurers. You can't buy a pig in a poke. You can't settle an inventory of claims that have never been examined. And so when courts focus on getting a settlement early instead of engaging with the merits of the entire case inventory, we're left in a situation where we lack the information necessary to actually bring things to a fair and efficient resolution. Before I burn all of my time on the problem of meritless claims, I do want to touch on sorry, I'm checking my time. There we go. I do want to touch on MDLs sitting on the court dockets longer than they should. I think we all know examples of large MDLs in particular that have gotten filed, and then there's a early rush of action, often mediation, often intense discovery on the defendant, and then they sit. And they sit, and they sit, and there's no real progress made towards settlement. There's no real progress made towards a final resolution. 16.1 also raises some tools to address that, and I'd like to talk about them briefly. The original proposal for Rule 16.1 raised as a case management topic what the court should do to facilitate settlement. Now, defense commenters on the rule, including myself, really raised the red flag on that, because an early focus on settlement to the exclusion of the merits is counterproductive. We are being asked to settle claims that we can't value, and we are being asked to do that without the information that we need to give to the people, our clients, and for our clients to give to the people they answer to actually settle claims. And the rule has now been changed, and instead of talking about efforts to promote settlement, we now talk about efforts to support resolution. And here's what the committee note says about this. Judicial efforts to facilitate resolution should include, quote, focused discovery orders, timely adjudication of legal issues, selection of representative bellwether trials, and coordination with state courts, end quote, not just mediation and other dispute resolution alternatives. In other words, the best jurists in this country who worked on MDLs sat down for 6 years and tried to create a rule. And one of the things that they say is you should not be focused just on settlement to resolve cases. You should be focused on finding ways to efficiently engage with the merits early, and that is what's going to promote settlement. It's going to promote settlement as a natural byproduct rather than end in itself, because the parties are going to be in a position to have the information they need to value the inventory, not just the claims and individual workup, but the entire claims inventory. And when parties have the information they need to value it, their valuations are going to be close enough that they'll reach a settlement on their own. I think that a focus solely on settlement, especially before we have those answers, is myopic and counterproductive. Now, I hope that this panel is going to have a chance to discuss some of the other problems that we have with MDLs, because there are certainly enough of them to fill the time, and how courts can use the tools they already have. Because again, Rule 16.1 doesn't give federal courts anything that they don't already have. State courts have these same tools. So I'd like us to talk about how we can use the tools we have to promote fairer and more just and honestly more efficient as well systems for MDLs, instead of focusing on the false efficiency of pushing early settlement without regard to the merits.
All right, thank you, Mr. Feldon. All right, Mr. Placitella.
Well, I was thinking about my cousin Vinny, but I'm going to throw out everything I prepared and just talk about a case study. I've been involved in MDLs dating back to the first MDL for asbestos before Judge Wiener. I'm currently the liaison counsel in the talc ovarian cancer MDL in Philadelphia. Some people hypothesize that there were as many as 100,000 potential claimants, but because of the way the MDL was handled, it's probably down now to about 30,000, 35,000, depending on who you're listening to. We've gone through 2 different judges, 2 federal magistrates, a special discovery master deciding the same issues in federal and state court. We've been through millions of pages of documents, hundreds of days of depositions, including the former FDA commissioner, the top scientists in the world, and thousands of pages of brief. We have addressed confidentiality, lawyer depositions, actually access to experts' laboratories, litigation funding, well, I won't go there, spoliation, fraudulent transfers, successor liability, disqualification of counsel, and coordinated hearings with state court. Now, Daubert hearings was something that addresses the exact issue that we're talking about. What the initial Judge Wilson did in the talc MDL is she front-loaded specific causation and general causation as part of the MDL. And what she did was, she said, okay, we're going to figure out what cases are going to go forward on the merits and which cases will not qualify. And we spent a lot of time doing that. And ultimately, she wrote a 70-page opinion after many days of hearings. And what could have potentially been a 100,000 claim MDL is probably a 35. And I'll talk to you a minute about the irony of all that as it went on. We then went through 3 bankruptcies in 3 different bankruptcy courts. And the last one, we still don't know where the current bankruptcy will end up. The Third Circuit dismissed 2. One of the esteemed jurists is here, who had the unfortunate experience of handling the bankruptcy court. But it was interesting. To say it was a field of dreams, I'm telling you it was not a field of dreams, okay? And then you talk about where does the jurisdiction of the federal court begin and the bankruptcy court end? And it's very, very interesting, right? Because and I don't know who is familiar with the Texas two-step, but that's at the heart of the battle in the talc MDL. And basically what happens is, and I'm not going to get political here, is there's a company that sold the product. That company is divided. The liabilities are put in one company, and all of the successful assets are putting in another company, and the company with the liability is then bankrupted, and then the fight begins. And the issue is, can you do that? I was, in Senate hearings over the propriety of that. The issue is still hotly contested in the legislature, and, that's where we are. So after 2 bankruptcies, now what happens to see how things turn? A 3rd bankruptcy is filed, this time excluding a significant percentage of the cases because they have been resolved in order to position for the 3rd bankruptcy. This bankruptcy is filed under 524G of the bankruptcy law, which is special for asbestos, and it says that you need 75% of the claimants to support the bankruptcy, or it doesn't work. Now, who votes? They go in with what they call a pre-pack, right? Who votes in that bankruptcy? That's an issue that will be hotly litigated, right? Because this is what happens. Remember all those cases that were excluded by the MDL court under their Daubert hearing, under their Daubert ruling? Somehow now, allegedly, and we'll see how it plays out, but allegedly, all those claimants that were excluded are now on the side of the defendant voting in favor of the bankruptcy. So where does the law of the case begin, and where does the law of the case end? So in one hand, the defendant in the case, when it's litigated in the MDL, says those claims should be out, and in the bankruptcy, the argument is, oh, but now they should be in because they will vote. And that will be ultimately litigated. The other thing that will be litigated, if it stays in bankruptcy court, is the ability of the bankruptcy court to impose its jurisdiction on the MDL and other state courts for the non-debtor, right? For the companies that have independent liability, whether they be another seller, a distributor, or another actor in the case. So that's where, so we'll see. The book is still being written, but to say that MDLs don't work, well, they do work, they did work. It's interesting, even when they do work, people don't seem to be happy with them on the defense side. And there's one statistic that is worth thinking about. A recent study has shown that only 3% of cases filed in MDLs get remanded. Now, on one side, you may say, well, that kind of defeats the purpose of the MDL because the purpose of the MDL is to ultimately get cases remanded. And some judges feel like they're actually not successful in an MDL if the cases don't resolve. But generally speaking, the cases do resolve. And the MDLs, if they're conducted properly, and everyone cares about what they're doing, do go in the right direction. So the talc MDL has not been a field of dreams, I'm telling you. But that being said, it has operated to a point where, cases that might have been filed won't be filed because the court has done its job. Now, one other thing before I close, in a prior conference here, we spoke about protective orders and what that means. Well, that's actually a hot issue in most MDLs, and it kind of comes back full circle. In the opioid litigation, for example, and there are findings in the studies show that protective orders are routinely granted in MDLs and in other cases, and the parties agree to them, and it's a way to get through places, but is it good for the public health? And the Sixth Circuit has actually recently looked at this. They looked at what happened in the opioid MDL. In the opioid MDL, there were documents and figures that were given to the federal government that the defendants did not want released, and they were protected. In fact, all the pleadings were sealed, except one state court let the statistics out because it wasn't inside the MDL, just for that state. And the Sixth Circuit, in reversing the protective order from the trial court MDL, said that this was a bad thing. And the fact that the protective order was entered shouldn't have happened, because the fact that the information got out actually helped stop the opioid crisis. That information led to congressional hearings. That information ended up providing a Pulitzer Prize and changed the public health in this country forever. So, and the MDLs have the opportunity, because 2/3 of the cases are probably products cases, the MDLs have the opportunity to do something great for America, and that is to keep the public health and safety front and center. And that means letting the information come out. And I'll hold the rest of my time, because I think I'm probably going to need it. Thank you.
All right, thank you, Mr. Placitella. Mr. Trask.
Hi, I'm Andrew Trask. I'm with Shook, Hardy & Bacon. I'm senior counsel there. I've worked on MDLs, if you count the ones that involve class actions, 20 to 25 years now, about as long as I've been practicing, as I'm thinking. I'm always older than I think I am. I don't know if any of you have that problem. And then the other thing I'll say is that I'm a big nerd, so I write a lot, and so I've written some articles that touch on MDL issues. I've written a book or two that touch on class actions and MDL issues. And I'll admit that I am very nervous sitting up here today, and I'll tell you why, because I think all my panelists share this. This is not my usual audience. My audience is frequently one judge, but it's never this many. And so all of us were sitting looking at the program beforehand, trying to figure out who might be listening to us talk, where we have to be careful because we have something pending in front of them. I'm lucky there, but of course I might wind up in front of you at some point later. So with all of that out of the way, I'll say that I'm particularly nervous talking to an audience of judges about the effect of the docket, or the effect on the docket of MDLs, because I see it from the defense practitioner's standpoint and occasionally from the law nerd standpoint, but I'm not living the docket day to day, and all of you are. So I'm not going to get up here and tell you this is a great thing for the docket or a terrible thing for the docket, or MDLs are a scourge or they're the greatest thing that's ever been invented, because I only have one limited perspective on that, and I'm paid to have that perspective a lot of the time. What I will try to tell you are 3 things I've observed as both somebody who practices in this area and who is a bit of a nerd on it. And so these are the 3 things that I've noticed about the effect on the docket that I think are worth considering and talking about. The first of those is that MDLs are big, and size matters when it comes to stuff like this. You know, size matters because size distorts our perception of the legal matters in front of us. This happens in class actions, and it happens in MDLs. And I want to read you the language of one judge who put it, I think, very well. I'm not saying that this is an accurate summation of what MDLs actually do, but I'm telling you this is exactly what one judge, faced with a very large MDL, thought as soon as he received it and had people in front of him. I'll tell you who it is after I read the quote. People aren't interested in depositions and discovery and trials. People aren't interested in figuring out the answer to interesting legal questions like preemption and learned intermediary doctrine, or unraveling complicated conspiracy theories. So my objective is to do something meaningful to abate this crisis, and to do it this year in 2018. Now, the judge there is Judge Daniel Polster of the Northern District of Ohio. These were his basically opening remarks to counsel when he got the opioids case. And that's the first thing that everybody heard, that this wasn't going to be about the law. It wasn't going to be about legal procedure. It was going to be about doing something, and doing something right now. Now, my dad told me long ago that one of the biggest mistakes you can make is to sit as you face a problem and think, somebody should do something. And this is something, so I should do this. That's not the way that good problem solving ordinarily occurs. And I'm not going to cast anything on Judge Polster, who I think has actually tried very hard and come up with some very creative solutions, some of which have been accepted, some of which haven't, to handle an overwhelming number of cases. But just doing something for doing something very rarely gets you very far. And the problem with cases like opioids, 3M, which I don't think we're actually allowed to discount. I think it's big, but it actually is an MDL, so it counts. The problem with cases like that is they're so large, they encourage us to do the first things we think of instead of running things through procedures that will actually carve things down. And the end result of that is you do get some cases that resolve reasonably quickly, but you get some cases like opioids or asbestos, which will go on forever. Now, an interesting story I want to tell about asbestos before I go on to my second point. Judge Rebrano, who was the one who wound up inheriting the asbestos docket in at the end of the 2000s, going into the 2010s, wound up writing an article about it in 2013 where he talked about his experience. And he said when he inherited this docket, it was dead but huge. It was like a giant tumor on his docket because he had all of these cases that hadn't gone anywhere for a long time. And so what he did was, instead of trying to do new and different things with them, he sat down and he decided on the principle, one claimant, one claim. And he started running individual claims through what you would ordinarily see as a legal process. Have they pled their claim properly? Do they have good legal grounds for it? Do they have facts that back it up? As he started doing that, some dropped out because it turned out there was no factual support for them. Some dropped out because it turned out there wasn't a strong legal ground. Some settled quickly because there were good facts for the plaintiffs and a good legal ground. But he managed to clear more than 50% of that docket within a couple of years. And the reason he was able to do that was because he managed to get started back again on the basic stuff that our legal procedure already has in place. I think the big mistake a lot of us make, plaintiff side, defense side, and possibly judicial side, is we see a very large conglomeration of cases settle in front of us, and we think, I got to do something, and it can't be normal procedure because normal procedure doesn't work on numbers this large. And that's not always the case. Point number two that I'd like to make that kind of goes along these same lines, and it's the thing that I think everybody always needs to remember, is that MDLs are a business. Now, I feel kind of weird talking to judges about this because judges are not in the business. Judges are in something called public service. You've all taken pay cuts. You sit in areas where you deal with large segments of the population that are very diverse, and you decide lots of different issues. If you were in it to be rich, you wouldn't be judges. But there are a lot of people out there who are very different and who are not in public service, and they wind up on both sides of MDLs. MDLs exist in part because there's mass production of products that sometimes go bad. There are mass production of information that sometimes goes bad. So that's the defense side of it. It's a business. The people that are getting sued on the defense side are businesses, and they respond with business tactics, including things like bankruptcy. But the plaintiff side's a business too, and we often forget that. Plaintiffs' firms that deal in MDLs deal in the manufacture and consolidation of large numbers of lawsuits. They advertise for clients. They take those clients in. They do not wait for the clients to come to them with a problem. They put out there that there's a problem and they're willing to do this particular type. They accept outside funding. They retain outside experts. They frequently use outside vendors for various problems. I'm not saying any of these things to say that plaintiffs' lawyers are bad or this needs reform, although some regulation might not hurt. What I am saying is these are the incentives that both sides deal with. And this is one of the reasons we see what we call a field of dreams problem. If you have a business in manufacturing and consolidating lawsuits, you're going to manufacture and consolidate as many of them as you can. You're not always going to double check to make sure you did it properly. To give you one or two cases where that's become an issue. The 3M case has, I can't remember how many cases now, but it's in the hundreds of thousands. 2 years ago, 70,000 of those cases were discovered to be duplicate filings, meaning of the cases that were in 3M, 70,000 of them were in there twice because two different counsel grabbed from referrers and signed up clients. Whether or not they did the due diligence, whether the client made a mistake, who's to say? But 70,000 were in there twice. In addition, of the 500 phase 1 cases that were worked up for trial first, 126 were dismissed, either voluntarily or involuntarily, for basic factual deficiencies. And when I say basic factual deficiencies, I mean, to use the federal term, Rule 8A stuff. The stuff that you would absolutely need to have a claim that you shouldn't file a claim without. That's one case. There are various other ones I could point to, but what I'm trying to point out there is, much as we accuse business people of cutting corners sometimes, and that's one of the things we see liability for, when you're in the business of manufacturing lawsuits, sometimes you cut corners, and that's something that we have to be careful about. And it's not something that can be solved through self-policing, any more than you would trust 3M itself to say, trust us, we'll self-police the earplugs, everything will be fine. Now, the third thing I want to point out about this distortion effect on MDLs and on the federal docket is that this magnifies once you've stopped using regular procedures and once you've forgotten that there's actually a business component to it, because what you wind up doing is putting things through a procedure that aren't right to start. There's another basic principle that I was taught early on by my dad, which is garbage in, garbage out. If you start with bad information, you wind up with a bad decision. If you start with poor raw materials, you're not going to wind up with a good product. If you start with cases that include a large component of valueless cases or a questionable legal theory or other areas where the information's been distorted at the beginning, you're going to wind up with distorted results. And this is one of these things that my colleague was talking about when he mentioned the fact that we can't start talking settlement early in a case when we don't know what we're talking about. We don't have the information to do it properly. What's really interesting is that one of the things that appears to be most useful is bellwether trial, but it's not the bellwether trials themselves that wind up useful in helping contain MDLs. It's the process of working up the cases. As it turns out, like in the 3M case, if you have 500 cases to start, during the workup of those cases for trial, a bunch of them will get voluntarily dismissed. It's one of the most frustrating things as a defense counsel to have your bellwether trial, to realize you got fantastic facts, to realize you're about to get the defense verdict on this one. That'll affect the settlement thing, and then watch it disappear. We can have a separate talk about how to deal with bellwether trials, because the gaming there is something that deserves some attention, but it's not what I'm talking about here. It's simply the fact that if you ascribe the best possible motives to everyone, what that means is the plaintiff didn't realize until they were working the case up for trial that it didn't have value. So it's the working the case through these regular processes that gets you to the place where you can start making the smart decisions. And that's the third thing that I just wanted to remind everybody of. So those three principles, just so you've got them if you're just writing down the bullet point notes. Size matters because size distorts. MDLs are a business. Garbage in, garbage out. That basically summarizes my understanding of the way in which MDLs affect federal and state dockets. It affects, it summarizes the way I see them in general. And I'll yield the rest of my time so we can actually maybe talk to each other.
Great, thank you very much. All right, I'm going to give each person 3 minutes to talk about anything that you would like to that arose organically during the conversation, and then that should give us a few minutes left for audience questions. So, Mr. Budner, you want to start us off?
Great. I was inspired by, I believe it was Mr. Burnham on the earlier panel, who was blunt and fiery in his retorts, and I think that makes for good TV. So, let me take some of those points in reverse order. Garbage in, garbage out. All right, well, it sounds like the garbage that went in went out. So what was the problem? It sounds like 3M worked, right? There were lots of claims filed, and the non-meritorious ones didn't actually receive any settlement, right? There was no money, and I think that undermines one of the core premises that I heard from Mr. Feldon about why MDLs create a field of dreams problem, which is that it's really easy for plaintiffs just to show up and cash a check at the end of the day. That's really not how it works. That's not how settlements are structured. Settlements almost always have some sort of claim form and proof requirement that weeds out claimants who don't have any injury or don't have any exposure. So I concede that, yes, of course, it's a business. I mean, but it's the business of justice, right? It's the business of finding people who have been wronged and righting those wrongs. And I don't understand the perspective from the defense bar that the plaintiffs' counsel are trying to manufacture garbage claims, because garbage claims go out. Garbage that comes in goes out and doesn't typically get paid. And so that's not, sure, there are varying degrees of scrutiny applied by different firms in different cases. But as a general matter, like Mr. Burnham was saying for his litigation financiers, which we don't use, by the way, there's no incentive for us to collect and sign up and submit claims that are not good. Does that mean that some of the scrutiny happens later in the process? It depends on the case. And I guess I would transition to one of Mr. Feldon's points about focusing on the merits early, because I actually think that's a little bit of doublespeak for not focusing on the merits early, right? Avoiding the merits of discovery on defendants, right? To create an earlier sideshow focused exclusively on discovery of plaintiffs to the detriment and the exclusion of advancing the case against defendants. And I would just suggest that is an approach that can be balanced. And sure, there are absolutely cases where early discovery of plaintiffs through plaintiffs' fact sheets and other mechanisms is appropriate. And I think generally the people in this room and across the country are doing a good job of figuring out which cases are best suited for those types of early procedures. Have I used my 3 minutes? Because I got.
You have 8 seconds.
Okay, size matters. Why is big bad? Why is it bad that lots of people get to walk through the courthouse doors and have their claims heard? I don't know that necessarily flows.
Thank you. Mr. Feldon.
Wow, I got called out by name, so I feel like I have to respond here. Let's see. I'd like to point out 2 things here. One is, we just heard that, sometimes the scrutiny of plaintiff's claims happens later, years later, after defense has spent a tremendous amount of money working up the claims, depositions have happened, and we're talking settlement numbers. Rule 11 requires that we do due diligence before we file a claim, and we need to know that we have a claim to file. And the aggregation of claims where it's see an ad, talk to a lawyer refers you to somebody you've never met before, who treats you as one more case in the case inventory, well, there you're not seeing a scrutiny, and there's no incentive to have scrutiny until, wait, we're talking about money. And meanwhile, the courts and defendants and other plaintiffs are harmed by these meritless claims sitting on the docket. Unless you believe that I am just making this up and exaggerating it, I would highly commend to you the supplemental comment on Rule 16.1 put forward by the Lawyers for Civil Justice, who were very involved in this rule on the defense side. For example, in the Ethicon MDL, 53%, or 46,511 cases, were dismissed for factual shortcomings or inability to establish an injury. Zofran, 40%. Vioxx, 30%. Abilify, 19%. Jules Lab, 17%. 3M, 15%, or let's see, what is that? Something like 48,000 cases were dismissed because the plaintiffs wouldn't fill out forms to actually prosecute their claims, wouldn't submit evidence, or there was no evidence to support their claims. Yes, we are finding these, and the notion that because we're finding 15% means that that's all there is to find is ludicrous. We are not doing a good job of requiring plaintiffs to show that they actually have a claim before we treat them like they have a claim. And I am not suggesting that we be focusing all of our attention on plaintiffs. That would not be efficient. But if you look at the way MDLs are conducted, you actually see the reverse is true. There is an asymmetry of information because during the first period, we are addressing common questions. And common questions are almost always going to revolve around the defendant's conduct, as opposed to the thousands of different plaintiffs who all have individual stories. What I am saying is that defendants need equity. We need a mutual exchange of early information. So that way defendants and plaintiffs can actually value the claims and have a basis in the law and in the data to go ahead and propose a settlement, which, as we all know, is really going to be the way of getting cases off the docket. And just as a very final point, I think it is important that early on in the case we be considering case management issues, because in the inimitable words of Yogi Berra, if you don't know where you're going, you're not going to get there. And we need to early on be figuring out what are the problems with MDLs and what procedures are we going to put in place to address them.
Perfect timing, Mr. Feldon. All right, Mr. Placitella.
Statistics are people with the tears wiped away. Okay? We're talking about statistics. I represent 300 ovarian cancer claimants. No advertising, no funding. I'm not being defensive here, right? I write checks every 3 or 4 months. I've been doing it for a decade because we believe in what we do. And you always want to define the problem by the outliers, but there are people who are dedicated. I represent the mothers and daughters of judges, of defense lawyers, and I agree that process matters, right? I agree that that's something we think we can all agree upon. In the talc MDL, and I'm not, just as a example, we had parallel discovery going on, liability and medicine at the same time, and the judge decided she would handle the medicine first, and the liability, would run its course. And we did both, and we did our job. And then when we were all done, the other side didn't like what it looked like, and they went to bankruptcy court. Statistics are people with tears wiped away.
All right, thank you very much, Mr. Trask.
I mean, I'm not sure what else I should say because I was the one who kind of got the first chance to talk about what everybody was talking about. But what I will say is this. Delay matters. If you have 500,000 claims and it turns out that 125,000 of them shouldn't have been there in the first place, there are judicial clerks and defense associates and eventually even plaintiffs' lawyers who are looking into those claims trying to figure out if they have any merit. If that had been done early, you can save a fair amount of that expense. You can probably also save some of the distortion on the docket. That's the reason why size matters. Size matters because size distorts. That distortion includes delays. And I'll say again, I'm not talking about whether or not MDLs are good or bad. MDLs began in 1968. They began with a series of antitrust cases involving electric utilities. They began because the utilities wanted the consolidation of cases. Much like Rule 23, at the beginning of the history of this jurisprudence, it was pushed by defendants because they saw efficiencies. And those efficiencies were realistic enough for them to push and get some things out of everything. The reason that you don't see defendants petitioning for MDLs as often anymore, which used to be the case, is because defendants don't see any upside to them anymore. What they see now are these distortions, and what they see is that it's better to actually just have these things as individual cases. I'm currently involved with an automotive set of cases that are all under the California lemon law that could have been consolidated in either the JCCP or in a federal MDL. But my clients decided not to do that because they could realize the same kinds of efficiencies by just doing them individually as they could have before under a consolidation process. If you don't get buy-in from everybody, you're not going to get the efficiencies. The reason why these distortions matter is because what you wind up seeing are areas where inefficiencies grow as people learn to game the inefficiencies in a system. That's, I think, where we're at with a lot of the MDL practice at this point. It's not that MDLs themselves are inherently good or bad. It's that at this point, there has to be some scrutiny of what's going on to make sure that the actual people with tiers that got hurt are the ones getting the compensation and getting it quickly. If there's anything you should take out of this from any of the lawyers up here, that of course should be the guiding principle for judges. And I know I don't need to tell you that, but that's ultimately what everybody up here is standing for, ultimately. You know, the people who got hurt should get compensated, and they should get compensated as quickly as possible. The question is, how do you get there best?
All right, thank you very much. Okay, it's now time for audience questions. We've got microphones on either side of the room. All right, well, seeing no takers, I'm kind of eager to start. We've heard a little bit about what each of you might want to say to judges who have MDLs. And we've heard a little bit about particular MDLs and particular decisions that judges have made under, unique factual circumstances. But this is sort of your opportunity to give some concrete advice to the judges who are handling MDLs about what we can do on the front end, about what you think we ought to be doing on the front end, so that MDLs are used effectively and as designed. What advice would you give judges?
I would start with pick your leadership wisely. People who believe in the case and are going to work hard and cooperate. And I think it matters up front.
All right.
And the process for that is subject to a long discussion.
I suppose that giving this opportunity to ask something of judges, I would ask, take the tools that you already have and use them to promote an MDL that is going to efficiently drive a resolution on the merits. A focus on settlement early without giving companies, plaintiffs, lawyers, everybody the answers they need is going to be counterproductive and result in a settlement that doesn't reflect the merits. If we engage early with the merits, if we use the tools at our disposal, we can get rid of these claims that shouldn't be there, whether they're meritless or just based on a legal theory that ends up getting disposed of. You can get the numbers down early. And it's only when certain informational benchmarks have been met, silver bullet legal issues addressed, a certain sense of what the inventory is, that you're actually going to get an efficient resolution that'll be led by the parties.
So it's hard to answer this question without being presumptuous. So first of all, I'm honored to be here and be speaking to all of you, and thank you for all the hard work that you all do. I would say this is, I guess, a little bit of a crib from Ted Lasso, is perhaps be curious. Make sure to ask, to really ask the litigants before you and ask the parties what they think the issues are. Be proactive in early case management to try to get the parties organized about what it is that needs to be decided and what the best order is to decide it. And continue to revisit that because, as we all know, litigation evolves, and what seemed like a good plan at day 1 may not be a good plan at day 700. So I'll leave it there.
All right.
I'm the writing nerd. I'll plug something I wrote first, which is an article for the American Journal of Trial Advocacy called 10 Principles for Legitimizing MDLs. The idea behind which was, if we didn't get something like Rule 16.1, what are we looking for and what do we think will make MDLs an effective tool? Because again, they're not going away. The only other thing I'd want to say to judges, and it's going to be at that high level again, is remember how the people before you see you. You're there to decide the legal disputes, and that actually does the job usually.
And I'll just, go ahead.
I was just going to say, how you define success matters, I think. The statute says the case is supposed to get remanded. It's not unsuccessful if the case gets remanded. Everyone thinks that unless the case is resolved, success hasn't been there. So defining success is, I think, part of the thought process.
And I would be interested in your comments on Rule 16.1. I mean, we heard a little bit about it, but do you think that Rule 16.1 is going to address many of those issues if used well, or
I think
is
it
there
is a
work
question
left
of-
to be done?
I think it is a question of if used well. And here's what I'll say, actually. There was a huge sort of battle behind the battle on the Rule 16.1 amendment. And the battle behind the battle was at least partially won in the Sixth Circuit during the opioids litigation. And that was when the Sixth Circuit came out and said definitively, the federal rules of civil procedure apply to MDLs in federal district courts. That had actually been a huge fight. And on the defense lawyer side, and I worked with lawyers for civil justice on their comment, and I submitted a comment of my own, that was the real thing we were trying to do, was to just get some court to recognize that the rules still apply. 16.1, I think, offers a lot of helpful stuff if courts are willing to dig down into it. I don't think it's a panacea. I don't think it was intended to be a panacea. And I don't think the fact that it is somewhat limited means it was a failure. I do think that it offers some great starting points. I think a lot of those other starting points are there in previous MDL cases and are there in just the basics behind. For federal judges, and I know there are state law counterpoints to this, Rule 1's always the critical one, fast, speedy, and just, or, now I forget it, but it's basically, cheap, fast, and just. So that's what we're aiming for.
Anybody else on 16.1?
I would just add that, I think that ultimately the drafters landed on a lot of discretionary language in the rule and recognition of the fact that you all are doing great work and applying individual facts, individual circumstances before you in a way that best fits the case that's before you, and that the laboratories are the trial courts, and it's not a one-size-fits-all approach for every single case. So I think there are absolutely some great suggestions and some great thoughts that emerge from that rule, and how they're applied will depend on the case before you.
I'd like to hop in with one thing here, only because it's, I think, one of the rhetorical battles that gets fought between plaintiffs and defense on this. One size does not fit all, but one size doesn't fit all for individual cases either. There's a set of rules, they work well. When you hear one size fits all, you're often being asked to make a departure for some reason. Ask yourself why that is, ask yourself who benefits.
All right. Please join me in thanking our panel.
Thank you. I've read your stuff.